Welcome to our annual Supreme Court review and preview. We're reviewing the highlights of 2017 and previewing a little bit of what we expect for the fall term of 2018. Of course, it's just another run-of-the-mill, quiet first Monday. Nothing unusual here, and we'll try to stay away from politics as much as humanly possible. The big news, of course, this term was the retirement of Justice Kennedy, and I did want to talk about that a little bit. Justice Kennedy was appointed by Ronald Reagan. He was on the court for 30 years. He was previously a Ninth Circuit judge for a number of years. He was known as a swing vote. I mean, I think that was his most salient reputation, although the New York Times called him an equal opportunity disappointer because he would sometimes side with conservatives and sometimes side with liberals. He's mainly known as a swing vote, I think, because even though most of the time he voted with a conservative bloc, I mean about 54% of the time over his entire career, on certain very significant cases he voted with the more liberal bloc, and some of those cases were in same-sex rights cases. Romer versus Evans, in which he authored an opinion that invalidated the Colorado law denying homosexuals the right to bring local discrimination claims. Lawrence versus Texas, of course, which invalidated sodomy laws. And then United States versus Windsor and Obergefell versus Hodges, which invalidated DOMA, the Defense of Marriage Act, and invalidated state bans on same-sex marriage. It is interesting. I mean, I think people think of him as swinging both ways, but really on close cases, he was actually vastly more often conservative. He voted with a conservative majority on 5-4 cases, close cases, about 71% of the time. But more than really any other justice during his career, anyway, he would sort of switch sides when it came to certain really significant issues. Some of the other issues that he switched sides on were, and particularly near and dear to me, because I'm a death penalty practitioner, were on death penalty cases. So he was the author of Roper versus Simmons, which held that it is unconstitutional to execute juveniles, people who committed their crimes before they were the age of 18. And he was also the author of the Hall decision in 2016, I think, which dealt with the standards for executing those with intellectual disabilities, a very significant case. His most famous case, though, may be Citizens United, which he authored in 2010. So with that, let me turn to just some statistics. Got to have a picture of our next nominee. And there's little that I could say about this that I either should say or hasn't already been said, although I do think we'll know fairly shortly whether we'll have a Supreme Court with 8 or 9 justices on it. All right, let's take a look at the numbers from the October 2017 term. There were 72 cases decided in 2017. The average is about 77, so this has continued a trend in the court taking fewer and fewer cases. As in the past, reversals outweigh affirmances. 74% of cases that the Supreme Court took cert on were reversed, 26% affirmed. That's a little bit of an increase in reversals. We always have which circuit did the best, or which lower court did the best and which did the worst. So I guess the best court of appeals would be the Court of Appeals for the Armed Forces, which had 100% affirmation. They had 1 case and it was affirmed. The Fourth Circuit, I guess, arguably had the best record because it had 0 cases decided by the Supreme Court, so none of their cases were reversed. The worst court of appeals by percentage reversed was the Sixth Circuit. They had a 100% negative batting record. 4 cases out of 4 were reversed. The Ninth Circuit, as it has in some years in the past anyway, had the highest number of cases reversed. They had 10 out of 12 cases reversed. Now, on vote splits, Again, as in past years, numbers are a little bit down here, but the unanimous decisions were, there were more unanimous decisions than split decisions. If you look at them just by the numbers, there were 39% were unanimous, 8% were 8-1 decisions, 16% were 7-2 decisions, 10% were 6-3 decisions, and in a fairly unusual number of 5-4 decisions, 27%. The number, although more cases were decided unanimously than in the other categories, this was the lowest rate of unanimity since 2008. Getting back to Justice Kennedy briefly, this was really the first time since the October term of 2002 in which he did not side at least once with the liberal wing of justices in a 5-4 decision. There wasn't a single case this year where he swung. So as you can see from the chart, in every other year, and in some years, some pretty significant swings on 5-4 decisions, but not this year. The swing vote this year, or last term in 2017, turned out to be Justice Roberts. He joined the liberal bloc in 5-4 cases more than any other conservative justice. It was just 2 times, but still more. And Justice Gorsuch joined the liberal bloc once. Most likely to be in the majority, Justice Roberts with 93%, followed by Justice Kennedy at 92%, Justice Gorsuch at 85%, Justice Thomas at 81%, Justice Alito at 79%, and then the liberal wing, less so, Justice Kagan 74%, Justice Ginsburg 73%, Justice Breyer 73%, and Justice Sotomayor at 68%, likely to be in the majority. Most likely to agree on case outcomes, so when we look at justices, who's essentially joined at the hip, ideologically at least, on decisions, Justice Ginsburg and Sotomayor were most likely to agree of any combination. They agreed roughly 96% of the time. Followed closely by Justice Thomas. Justices Thomas and Alito at 93%, Justices Breyer and Kagan at 92.6%, and then it kind of went down from there. Interestingly, Justices Roberts and Kennedy were most likely to agree on outcome about 90% of the time. Most majority opinions authored. I hadn't been really keeping track of this and was sort of surprised when I looked at the statistics. Justice Gorsuch authored 5 opinions. Justice Alito 4, Justice Thomas 3, and then the rest of the court either 2 or 1. In terms of most dissents written, Justice Sotomayor wrote 9, Justice Thomas wrote 8, and then it kind of went down from there. The fewest dissents were written by Justice Kagan, who had just 1 dissent, and Justice Kennedy had 2. So a little bit of a takeaway, I guess, in terms of these statistics. It's, at this point anyway, it looks like this is the Roberts Court. Justice Roberts has really taken on the mantle of the swing vote, and that's, I would say that's sort of consistent with his deeply and often expressed views about the importance of the institution of the court and the importance of trying to build consensus among the justices. For those of you who probably or who are lucky enough to have gotten notice about it, maybe tickets, Chief Justice Roberts is going to speak at the University of Minnesota's Law School, the Stein Lectures, in about 2 weeks. You may still be able to get tickets. I think they were kind of a hard thing to come by, but he should be really interesting. I don't know if any of you have gone to any of the other times that the Supreme Court justices have come and spoken, but it's always great. So if you can go, I'd heartily recommend it.
So with that, we'll dive in a little bit deeper into some of the key decisions from the last term, the 2017 term. And the first 2 that are interesting to discuss is that the Supreme Court twice last term overruled precedent. And the reason that's somewhat significant is, of course, since Justice Kennedy's retirement and with President Trump being able to appoint a new nominee, there's been a lot of discussion about stare decisis. And in what circumstances, if ever, the Supreme Court can appropriately overrule its past precedent. And abortion rights have certainly been kind of the focal point of that discussion. So with that in mind, again, just this past term, the court overruled precedent twice in cases involving constitutional related issues. The first is Janus v. AFSCME Council 31. And in this case, the petitioner was an Illinois state employee who refused to join his public sector union because he disagreed with its public policy positions. There was an Illinois law, however, that required the petitioner to pay the union a fixed agency fee, which was a percentage of the union dues representing the union's collective bargaining, but was distinct from the union's political or ideological activities. The law in Illinois and in other states that had similar laws was consistent with the Supreme Court's decision in 1977 in Abood v. Detroit Board of Education. That case involved the same issue where, again, a public sector employee looked to challenge the union fee requirement on First Amendment grounds. The court in that case kind of cut the baby in half in some respects. It recognized that there was a First Amendment problem, that the government was forcing public sector employees to pay union fees, fees that could go to political activity that the employee doesn't agree with and doesn't believe that they should have to subsidize on First Amendment grounds. But the court in the Abood decision also recognized a free rider problem. And that was that these employees, by opting out of the agency fees, were still able to free ride and take advantage of the collective bargaining activities that the union engaged in. So the solution in Abood was to uphold mandatory agency fees to public unions so long as those fees are used for collective bargaining activities and are not spent by the union on political activities. And the Illinois law was consistent with that. California had a similar law, for example. But over the years, the Abood decision was criticized. Part of the criticism was arguments that there was too gray and hazy of a line between what's political or non-political activities. And what you started to see over the past decade is the Supreme Court in a number of decisions hinting at its discomfort with the Abood decision and its willingness to overturn it. So in 2012, there was the Knox decision, where Justice Alito was in the majority but expressed doubt about Abood and its holding. 2 years later, there was the Harris v. Quinn case, where Justice Alito suggested that the court would be willing to overturn Abood. But the petitioners in that case were not actually public employees, and so the case was tossed on those grounds. 2 years later, the California law was in the crosshairs, and it was expected that on 5-4 ideological lines with the conservatives prevailing, that Abood would be overruled. The case was argued in January 2016 to a full court, but then a month later, Justice Scalia died. And so when the decision was issued, the California law was upheld by a 4-4 equally divided court. Fast forward to this term, there are 9 members on the court again. This Illinois case goes before the court, and in a 5-4 decision, the First Amendment is held to overrule the Abood decision and hold the Illinois statute impermissible. So Justice Alito, who had kind of been the voice for these prior decisions, again wrote the majority opinion here and took stare decisis on front and center. It said that the concerns about free ridership that were voiced in Abood haven't come to pass. The federal union public sector employees aren't required to pay agency fees, and Alito said that the sky hasn't proven to be falling there, and said that Abood was poorly reasoned and gave inadequate attention to the First Amendment principles, argued that it was an unworkable solution, the line that Abood tried to draw was unworkable, and said reliance interests are relatively minimal as well. The only dissent that was written this past term by Justice Kagan was written here, and she criticized the court in succeeding in its, quote, 6-year campaign to reverse Abood, and said that its decision will have large-scale consequences, and said that judicial disruption does not get any greater than what the court does today. I think one interesting takeaway, and I was at the 8th Circuit Judicial Conference earlier, and a constitutional law scholar commented on this as well, is that is that you had a series of decisions kind of chipping away at Abood. So while Abood was certainly overruled and stare decisis did not prevail, it's hard to say that the decision by the court this term was surprising. In fact, this is the result that everyone expected and thought would be handed down 2 terms ago before Justice Scalia's passing. The other case where precedent was overruled was in South Dakota v. Wayfair. So this case involved sales tax, involved the imposition of sales taxes. So under the law, a state can impose a sales tax on a consumer's purchase of goods or services, but there are 2 prior Supreme Court cases that have held that an out-of-state seller cannot be required to collect and remit that tax to the state the same way that happens if you go into a local department store, for example. The 2 prior cases were the Bellis-Hess case from 1967, and then the Quill decision, which affirmed the prior rule that came down in 1992. And those cases established what's called this physical presence rule, that the retailer needs to have a physical presence in the state before they can be required to collect and remit that tax. And it's rooted in dormant Commerce Clause jurisprudence. Now the rule has been criticized before, including in Quill itself. There you had Justices Thomas and Kennedy, among others, saying that they disagree with the original rule, but invoking stare decisis affirmed it there. Here, however, the rule was reversed. The South Dakota passed a law directly aimed at challenging this statute, and South Dakota actually did a very good detailed job of including legislative findings, the fact that the court expressly relied on. South Dakota does not have an income tax. It talked about the $50 million in sales tax revenue that it misses out on every year. It passed this law to challenge the Supreme Court precedent and brought a declaratory judgment action right away against Wayfair.com, Overstock.com, and Newegg. The Supreme Court in a 5-4 vote overruled its prior decision, but here Kennedy wrote, but Justice Ginsburg joined the more conservative members of the court, while Justice Roberts joined the other more liberal justices, and Justice Roberts writing the dissent. One thing that's interesting here is that, there's often a discussion about how much 70 and 80-year-old justices pay attention to changes in technology. And technology was front and center in this opinion. Justice Kennedy talked about how the prior decisions were written in a time where you were dealing with mail order catalogs as establishing the rule, and now you have online retail, which has completely changed the landscape and changed how the court should view the prior decisions. One thing that's interesting here, I think, in terms of Chief Justice Roberts' dissent and a signal for how he may vote in terms of stare decisis in the future, is he recognized that he said Quill was the wrong decision. It's the wrong rule of law. But stare decisis has extra significance when Congress could make the fix instead. And here in the case of the Dormant Commerce Clause, Congress could have chosen to expressly act instead. And he said that for all the reasons Kennedy was flagging about online retail and the explosion in commerce, he said that's all exploded in part based on everyone's expectations that sales tax can't be collected, that outside state retailers don't need to collect it. So that was a key distinction drawn there.
The next case is the latest in a series of decisions by the Supreme Court in which they've enforced arbitration agreements in the face of claims by plaintiffs or appellants who say that the arbitration agreements frustrate the purpose of a particular statute. The statute that was involved here was the National Labor Relations Act. The plaintiff in this case signed an employment agreement that had an individualized arbitration provision in it. So the arbitration clause forbade collective actions or class actions. But the plaintiff here and in a number of related cases had initiated class or collective actions under the Fair Labor Standards Act under the FLSA, and their argument was that there is a concerted activity provision in the National Labor Relations Act that allows employees to engage in concerted action, and that the ban on collective actions or class actions would contradict that. And so that they thought that there was because of the savings clause in the Federal Arbitration Act, that in this limited circumstance, the arbitration limitation should be swept aside, and they should be allowed to bring their claims in court as a collective action or a class action under the FLSA. That was rejected. And again, kind of the same rationale that has been employed in a number of Supreme Court cases was employed here. And essentially the court said that if the legislature wants to create an exception to the very broad mandate in the Federal Arbitration Act, they have to do so a lot more specifically than this reference to concerted activity in the National Labor Relations Act. So it was a 5-4 decision, straight down lines, Roberts, Kennedy, Thomas, Alito, and Gorsuch, and the majority. Justice Ginsburg wrote the dissent for this, arguing that it would be that this would really limit employees' ability to enforce the FLSA and enforce wage and hour standards, because as an individual, there was so much less incentive for them to do that. And the collective, she argued that the collective action provisions of the Fair Labor Standards Act were really critical for the enforcement of the FLSA. She took the unusual step, and very rare step for her, of actually reading her dissent from the bench to emphasize how much she disagreed with the majority here.
So if you're legally betting and losing on the Vikings so far this year, you can thank the Murphy v. NCAA decision for making sports gambling legal again. So this decision, this case arose from Congress's passage in 1992 of the Professional and Amateur Sports Protection Act. Congress chose not to actively regulate sports gambling, but instead passed a law that prohibited and made unlawful states authorizing sports gambling. The law did have a grandfather provision, so if you're wondering why why Nevada and Las Vegas has been able to survive over the years, it's because Nevada was grandfathered in. New Jersey also had a 2-year option where it could have enacted sports gambling, but New Jersey didn't do so within that 2-year period of time. Instead, it waited 20 years and then decided that it wanted to engage in sports gambling and passed a law making it permissible to do so. The district court in Third Circuit shot that down. They cited the federal law and said, you know, it's unlawful for you to authorize sports gambling. New Jersey legislature goes back and gets a little bit cuter, and this time in 2014 passes a law that doesn't enact anything new, but instead repeals the laws that were already on the books prohibiting sports gambling. And this was also invalidated again by the district court in Third Circuit en banc. It gets to the Supreme Court, which invokes the anti-commandeering doctrine, which the court recognized, quote, may sound arcane, but said that it invalidates the federal law here and is simply the expression of a fundamental structural decision incorporated into the Constitution, the decision to withhold from Congress the power to issue orders directly to the states. So when I was in law school, the Supreme Court in the 1990s issued a couple of decisions involving the anti-commandeering principle. So for example, Congress was not permitted to pass a law requiring states to take title to low-level radioactive waste, or Congress was not allowed to require state officials to engage to conduct background checks for handgun-related legislation. What the federal government argued here, as well as the NCAA, was that the anti-commandeering provision may preclude Congress from ordering the states to do certain affirmative activity, but certainly doesn't preclude Congress from saying it's unlawful for a state to authorize sports gambling. The court said that's a distinction without a difference. Basically, conspicuously absent from the list of powers given to Congress is the power to issue direct orders to the governments of the states. And when I first read the decision, I thought, well, what about preemption? You have Congress all the time is enacting express preemption provisions, or you have conflict preemption or field preemption. And the federal government, again, made that argument. But the court said what's key is even if express preemption provisions aren't always framed the most artfully, Congress in all those cases is actually regulating the conduct by private actors. And then under the Supremacy Clause is simply saying, we alone are going to be the ones to regulate here, and we're boxing states out. And it said that's fundamentally different than issuing an order directly to the states either requiring them to take certain conduct or expressly precluding them from taking certain action. So it was a 7-2, a 6-3 decision, so not particularly close. Alito wrote for the majority. One other interesting, I guess, practice pointer is, and an interesting thing from it, is the severability issue. And I was at a conference where they actually had the two parties to the case talk. And in the New Jersey law, and the federal law not only invalidated, said states aren't authorized to make sports gambling legal, but it also had a separate parallel provision precluding private actors from engaging in sports betting if it was done if they were doing so pursuant to one of these state schemes. And so given the kind of the preemption, anti-commandeering distinction, you would think, oh, well, that separate provision could be severable and survive. The federal law also, regulated private actors. But the court just kind of axed the whole thing, and the dissent took some criticism with it. But, I think it's a reminder that, it doesn't hurt sometimes to try for the home run and see how much you can get, because even the party of the case realized they got a little bit lucky here in getting the whole law struck down.
The next case, Lucia versus SEC, involves the Appointments Clause, a clause that doesn't get a lot of examination by the Supreme Court, but came under scrutiny in this case. The Appointments Clause, if you missed it, requires that all officers of the United States be appointed by the President, by courts of law, or by the, quote, heads of departments, close quote. The issue in Lucia versus SEC involved SEC administrative law judges, and the question is whether they were officers of the United States and therefore had to be appointed by the heads of the department, courts, or the President. The ALJs at the SEC, the ones who hear administrative actions involving anti-fraud provisions, things like that, are appointed by staff at the SEC, or at least they were until this case. And the question was whether or not that was essentially improper, so that the decisions of those ALJs should be rendered ineffective. And Mr. Lucia, who had been held to have violated an anti-fraud provision, argued that in his particular case, that the ALJ that heard his case was not appointed by the head of the SEC, not appointed by the commission itself, but rather by one of the staff, and so that the outcome was invalid, essentially. The court took a look at this, and interestingly, the government refused to back up the SEC in this case. And so the government argued on the side of Mr. Lucia, and the court had to actually appoint a former law clerk of Chief Justice Roberts to defend the SEC. And so that's the posture in which this went to the Supreme Court. In a decision that was 7-2 and joined by everybody except for Justices Ginsburg and Sotomayor, and actually authored by Justice Kagan, the court held that, in fact, Mr. Lucia was right, that the ALJs were officers of the United States, and that meant they had to be appointed by the SEC or by the President or by courts of law. Right after the cert was accepted, the SEC ratified the decisions, or ratified the appointments of the administrative law judges whose appointments had been called into question by the case. So there really wasn't an issue at the time of the decision whether or not the ALJs were operating inappropriately. But they did have to determine whether or not Mr. Lucia's particular determination was invalid, and they found that it was in this 7-2 decision. So this decision could have pretty broad ramifications for any other federal agency that uses ALJs, in which the ALJs are not appointed by the head of the department, so by the commissioner agency, or by a court of law, or by the President. And they can solve that, it's pretty clear, by ratifying any staff picks of ALJs. But it does call into question the validity of opinions by ALJs who haven't been appointed in that method. Is this yours? think this is yours.
The court issued two decisions this past term in the antitrust area. The first is Ohio v. American Express Company. And this is a case that gets into a little bit of the weeds in terms of how to litigate a rule of reason case. So the antitrust laws under the Sherman Act prohibit unreasonable restraints of trade. And those that aren't per se unreasonable are instead adjudicated under the rule of reason, which is a fact-specific assessment of market power and market structure to assess the restraint's actual effect on competition. The allegation that was raised here by 10 state attorney generals was that credit card companies were engaged in antitrust violations with respect to how they, in terms of their scheme on the merchant side of sales. So credit cards make money two ways. You know, they charge interest to consumers, and then they also charge a transaction fee to merchants. And what credit card companies, with American Express being the most notable, Visa and MasterCard had these as well for a while, were anti-steering provisions. So American Express's business model was based on charging higher merchant fees, but providing better card member services to its consumers. And the way that it avoided, the way that it made sure that it was able to obtain those higher, actually get those merchant fees to go through, was to include anti-steering provisions in its contracts with merchants. So merchants at the point of sale, if they agreed to the contract with American Express, weren't allowed to push the sale, try to encourage, to instead use Visa or Discover or something like that. The rule of reason analysis has a burden shifting framework. So the first step is that the plaintiff has the burden to show a substantial anti-competitive effect that harms consumers in the relevant market. If they can make that showing, it shifts to the defendant to show pro-competitive rationale, and then back to the plaintiff to show that it couldn't be achieved through a less competitive means. Here the issue is, what is the relevant market in that first step? Again, the plaintiffs here, the states bringing the action, so the relevant market here is the merchant side, and so try to show the anti-competitive effects by these anti-steering provisions. Visa and MasterCard, who were sued, folded very early. They entered into consent decrees and dropped their anti-steering provisions. American Express chose to litigate this all the way through. It involved a 7-week bench trial, and then losing before the district court, before taking it to the Court of Appeals, getting a reversal there, and then it going to the Supreme Court, which found for American Express in a 5-4 vote. The Supreme Court said that the district court looked at the wrong, focused on the wrong market, and that here where you have a situation where both transactions need to occur in each instance, that the market needs to include both sides. So the court, Justice Thomas writing, explained how in any time you have a credit card transaction, it's not just solely whether the merchant is going to take that American Express card, but it also requires having a consumer in the store who has that American Express card in their wallet and wants to use it. In terms of the scope of this decision, it'll be interesting. It's limited right now kind of to the credit card industry, but could certainly have impacts further on. And shows, in terms of a litigation practice pointer, shows the importance to try your case right and put in as much evidence as you can right away. The states focused solely on the market side and just didn't have evidence in the record to support the two-party model, and therefore the Supreme Court tossed the case. And it's interesting to note again that American Express was willing to litigate this all the way through. It was, I'm sure, an expensive fight, but they were able to prevail. The other antitrust case with really kind of broader international law implications is Animal Science Products v. Hebei Wellcome Pharmaceutical Company. And here, Animal Science is a Texas-based company that uses vitamin C in the livestock supplements that it manufactures. And it brought an antitrust suit against Hebei Wellcome Pharmaceutical, which is a Chinese company, in the U.S. courts. And what Animal Science alleged was that Hebei Wellcome and other Chinese manufacturers had fixed the prices of the vitamin C that they sold to the United States, which they claimed was a violation of U.S. antitrust laws. The Chinese sellers moved to dismiss on the ground that Chinese law actually required them to fix the price and quantity of vitamin C exports, and thus they should be shielded from U.S. antitrust law liability on international comedy grounds. What's notable is that in this case, the Ministry of Commerce of the People's Republic of China actually filed an amicus brief in support of the motion. They explained that they're the administrative agency authorized to regulate foreign trade, and stated that the alleged conspiracy here was actually a pricing regime that was mandated by the Chinese government. The district court here denied the Chinese seller's motion to dismiss, saying that it did not view the ministry's statements as conclusive. The U.S. purchasers, who were the plaintiffs, had brought forth other evidence that the ministry had not been able to identify any specific law or regulation ordering the Chinese seller's agreement or any specific explicit involvement by the Chinese government. And so the district court denied the motion to dismiss. The Second Circuit reversed. It said that the district court gave should have given more deference to the ministry. In fact, it said that that a court is bound to defer whenever a foreign government, as here, directly participates in a case in U.S. courts by offering sworn evidence about the construction and effect of its laws and regulations, and that evidence is reasonable under the circumstances presented. The Supreme Court here, in a unanimous 9-0 decision, authored by Justice Ginsburg, vacated the Second Circuit's decision. And its decision really isn't all that surprising when you look at the text of Federal Rule of Civil Procedure 44.1, which is what the court based its decision on and governs decisions regarding foreign law. The text of that rule says that the court may consider any relevant material source, whether or not submitted by a party. The accompanying advisory comment specifically states that the court may engage in its own research and consider any relevant material thus found. So the court held that respectful consideration should be given to a foreign government submission, but the court is not bound to accord conclusive effect to the foreign government statements. So on the one hand, while that seems to be certainly grounded in the federal rule, on the other hand, that does seem to raise kind of significant international comedy concerns. Here, this was a case where the ministry, the Chinese ministry, actually appeared in the lawsuit. In fact, China appeared at oral argument, which is highly unusual. Usually the only amicus who's allowed to participate at oral argument is the United States. And you can kind of query how a foreign government or how the U.S. would feel if it had, if the Supreme Court had issued an interpretation of a federal statute a certain way, and then a foreign court said, well, based on what I'm additionally going to look at, I actually don't think that's quite right, U.S. But here, a unanimous decision.
Let's go back to the travel ban. We'll talk about it. Sorry, we got a little out of order on this one. Let me just talk briefly about Trump versus Hawaii, which was the travel ban case. The president had issued a series of proclamations restricting entry into the United States of persons from a number of different countries. And the third one is the one that actually made it to the Supreme Court. The other two were enjoined by other federal courts, and the president kept revising the proclamations. So in the version that came to the U.S. Supreme Court, there were several Muslim-majority countries from which travel was banned, and also North Korea. There were three questions that the court looked at. One is this even a justiciable controversy? Is it one in which the courts really have a say, given the broad authority given to the president? Second, was there a violation of the Immigration and Nationality Act here? Did the president exceed his authority, as the lower courts had found when it banned all travelers essentially from these countries, or restricted all travelers from these countries? And then third, was it animated by religious bias? Was it a Muslim ban, and therefore did it violate the Establishment Clause? The court held in a split decision, 5-4, authored by Justice Roberts, that the controversy is justiciable, that this is a question for the courts, but it held that the president did not violate the provisions of the Immigration and Nationality Act, because that act provides very broad authority to the president to deal with immigration and travel, and given that broad authority, that there wasn't a violation. And third, they found that there wasn't a specific indication that the president, that the proclamation itself was animated by religious bias. It noted that North Korea was on the list, and that these were, I think all these countries were countries in which the State Department had found they were state-sponsored, countries that involved in state-sponsored terrorism. So the court upheld the proclamation, and I don't think that was a huge surprise to most people. I think the most interesting part of that decision was its finding that this is a justiciable controversy before the court, and may come back again under different circumstances. So the next decision is Carpenter versus United States, a very important Fourth Amendment case involving search and seizure of cell phone site records. So these are cell tower records. In this case, the defendant had been convicted of armed robbery, engaged in a series of armed robberies, and the police had essentially apprehended him and developed evidence against him by getting about 150 days of his cell phone records, which obviously were in the hands of a carrier, and then tracking his whereabouts based on the pings on cell towers. So they had, this guy must have used his cell phone a lot, because they had about 110 pings a day, and were able to pinpoint with great precision where he was on any given day during that 150-day period. And they used that evidence to pinpoint him as being very close to this series of crimes that had occurred. The argument really involved two different conflicting theories. So one is, you may remember from, I think it was 2 years ago, the court held that it was a violation of the Fourth Amendment to put a GPS tracking device on someone's car and then to track them without a warrant. That was held to be essentially an invasion of privacy and a violation of the Fourth Amendment. But there is a contravailing doctrine called the third-party doctrine, which says if you give your personal information to a third party and it's stored in a third party, the police don't need a warrant to go get it, because you've essentially given up your right to privacy. Justice Roberts, in writing this decision, noted that, first off, that cell phones had become basically indispensable in modern society, and everybody had them, and that they are so accurate that it's like putting an ankle monitoring device on you when you walk around. I always thought that's pretty accurate. I always refer to my cell phone as my electronic leash. So he found that this was, that because of the ubiquity of cell phone usage and its accuracy, and the notion that it is so unlikely and so contradictory to our notions of privacy that government can track where you are basically every minute of the day, that this was a violation of the Fourth Amendment and that warrants would be required in similar circumstances. He was very careful to say that this was a narrow reading, and he suggested that if the police had an emergency and they needed to get a hold of somebody's cell phone records right away, he wasn't ruling that out. He also indicated that if you were seeking cell phone records for maybe a shorter period of time, that might be an exception too. So he kind of hedged the bets a lot for what may happen in the future. The dissenters in the case said basically that the majority's opinion just wasn't specific enough to give guidance, and now law enforcement wouldn't know when they needed to seek a warrant and when they wouldn't, and suggested that there would just be kind of a crazy quilt, a patchwork of Fourth Amendment decisions trying to deal with cell phone records that's just unworkable. The next case, National Institute of Family Life and Advocates versus Becerra, is a case involving the First Amendment. So in this case, there were pregnancy consultation centers which don't offer medical services. They generally counsel people towards adoption or some other something other than abortion as a remedy for an unplanned pregnancy. California passed a law requiring that those pregnancy counseling centers that were licensed had to tell their patients or the people that they were counseling about the state's provision of low-cost abortion services and where they could get them. And there was another part of the law that said if it was an unlicensed center, they had to tell the people using the services that they were not providing medical services. The plaintiff in the case of Pregnancy Counseling Center claimed that this was a violation of their First Amendment rights, that they were being forced to say things that they didn't have to and shouldn't be required to. And the court sided with the plaintiff in the case. And a majority decision, or conservative majority decision, 5-4, the court held that the California law was unconstitutional because it did violate their First Amendment right. Justice Breyer wrote a dissent essentially pointing out that if doctors who provide abortion services can be constitutionally required to tell patients about adoption services, that, in his words, sauce for the goose is sauce for the gander, and that these pregnancy counseling centers could be constitutionally commanded to give similar information on the sort of the flip side of the issue to its patients. But he was in the minority, as they say.
So particularly for those who are live here in Minneapolis, it's of note that there were two cases from Minnesota that made it to the Supreme Court this year. The first, Minnesota Voters Alliance v. Manske, was certainly the higher profile of the two. And it dealt with a Minnesota law that provides that a political badge, political button, or other political insignia may not be worn at or about the polling place. And numerous states have laws that similarly try to restrict in some way what can be worn or what kind of politicking can be done at the polling place. But Minnesota's law was somewhat unique in that it had a separate provision barring campaign-related material, but this provision about political badges, political buttons, or political insignia was broader than that, and political was not defined in the statute. And this came to a head in the 2010 election. Tea Party related groups had decided to wear T-shirts to the polls and to also wear, and for some of those groups to wear buttons that said, "Please ID me." And if anyone remembers, voter ID was certainly a topic that was discussed around the 2010 election, but it actually wasn't it wasn't an item on the ballot itself. And even though the different candidates for office had voiced their various views in terms of whether they'd be for or against voter ID, election officials, kind of catching wind that this was going to happen, issued an election day policy to different county officials to give them guidance for what was appropriate or not appropriate to wear under the Minnesota law. And so that would be something, saying Democrat or Republican or identified with a particular candidate, but was also intended to extend to the "Please ID me" buttons. So the law was challenged on facial First Amendment grounds, and the Supreme Court in a 7-2 vote struck down the Minnesota law as unconstitutional. The opinion was by Chief Justice Roberts, and Breyer and Sotomayor were the two dissenters. What's interesting, I think, is anytime you have a constitutional law question, you kind of right away go to the different standards of review. Is it strict scrutiny, rational basis review, intermediate? And here there was a recognition that since the law applied to the polling place itself, the polling place is one of those sacred civic places that only needs to survive rational basis review. It's the same thing as what you might be allowed to do on First Amendment grounds in the courtroom itself, as opposed to the courthouse more at large. And so Chief Justice Roberts that recognized that there's a relatively low bar here. The restrictions simply have to be reasonable, but said that the restrictions, or kind of the lack of definition here, was not reasonable and did not survive. And this was really kind of fleshed out at oral argument, where every justice had their kind of favorite hypothetical that they would throw to counsel. It'd be things like, well, what about a T-shirt with a rainbow flag design? What about something that says the NRA? What about #MeToo? what about a Colin Kaepernick jersey? What about a Boy Scout uniform? All these things that, are sometimes politically charged but aren't necessarily appearing on the ballot. And the state's position was that it would need to be issue-oriented material designed to influence or impact voting in a way that, what might be precluded as political in one election, years later might not be political in the same way because of the issues that are at issue in a particular election. And the court just found this to be unworkable. A rule whose fair enforcement requires an election judge to maintain a mental index of the platforms and positions of every candidate and party on the ballot is not reasonable. And one example that was kind of fleshed out by the slide here is that Justice Alito asked, well, if you had the text of the Second Amendment on your T-shirt, would that be political? And the answer there was yes. But when the question was asked about the First Amendment, it was said, well, that might be permissible.
Wrong answer.
Wrong answer. So the good news is, Steve or anyone else, correct me if I'm wrong, but I don't think Minnesota has put a new law on the books. So feel free to reach deep into the closet come November, and you can vote without being asked by any election judge official to, put a sticker on or turn your T-shirt inside out, which is what the protocol was actually under the prior Minnesota law. The other case I think we'll kind of skip for purposes of time. The most interesting thing about it is it reminded me that there is actually a contracts clause in the Constitution, which sometimes isn't always front and center on the list of different constitutional provisions. It dealt with divorce decrees and where life insurance benefits go.
All right, next I'm going to talk about two cases that were really much anticipated, but ended up being not really a big deal because the court kind of ducked the significant issues in both those cases. The first one is Masterpiece Cake Shop. So in this case, there was a baker in Colorado, and the baker sold off-the-shelf bakery products, pastries and whatever, and he said, I will sell those to anybody. But he said that he should not be compelled to actually create a wedding cake for a gay couple because that offended his notions of what was religiously appropriate or correct. The plaintiff the complainant in those cases was the gay couple who had asked him to bake the cake. They took it to the Colorado Human Rights Commission, which essentially found that there was a violation of the anti-discrimination laws in Colorado. And so as the case came up to the U.S. Supreme Court, it was really a very interesting conflict of maybe three different fundamental principles. You had the anti-discrimination claims, which had been on the books for a long time, but you had First Amendment lawyers saying that there was, you shouldn't be required under the First Amendment to create something, that the government doesn't have the right to force artists to create. And everybody conceded that a fair deal of art was required to make a wedding cake. And again, the distinction that the baker made was, look, I'll sell them off the shelf thing, so I'm not refusing to, this isn't a refusal to service case, a refusal to serve. Just like at the lunch counter, they can have hamburgers and all that kind of stuff. So it's not like the civil rights cases from the '60s. I just don't want to be forced to create a work of art. And then there was another arm that said essentially this violated the baker's rights under the Free Exercise Clause, and that this was an infringement on his religious rights, even though there's a long line of cases that suggest that or that say that you don't have a religious right to discriminate. You can't say that I refuse to serve African Americans or Jews because my religion requires it. So there was this, it was kind of in conflict with this long line of cases. But there was some wondering aloud whether the court would find a First Amendment right to discriminate, or whether the court would maybe extend the logic of the Hobby Lobby case into this area. Instead, the court ducked the entire issue, and it found that there was a bias statement by a member of the Colorado Human Rights Commission, and that indicated that it had been sort of religiously motivated, and so they sent the case back down on that ground, but really didn't address any of those key issues. The second one that was more fizzle than sizzle is the gerrymandering case, political gerrymandering. So the court in some cases dating back to Pennsylvania several years ago had stayed out of the political gerrymandering disputes as opposed to racial or other aspects for gerrymandering. But the court took this one, and the question was whether there's a practice called crack and pack, which I thought was a reference to their football team, but apparently has to do with how many Democrats you can stuff in the smallest areas so that they don't contaminate Republican areas, or separate strong Democratic areas so they don't have voting power. And apparently there was evidence that had gone on in Wisconsin to the point where statewide, I guess, there were in the Wisconsin House, although Republicans were getting about 48% of the vote, they had about 60% of the seats. So it looked like the court was going to wade in for the first time into this area of political gerrymandering, which it has just studiously avoided until now. But no, it did not wade in. It held that the grounds for standing asserted by the plaintiffs in this case had to do with the uneven effects of gerrymandering on a statewide basis as opposed to a district basis. And so it held that they didn't have standing on that ground. In fact, that was a 9-0 decision on that. But in a 7-2 part of the opinion, they sent it back to allow the plaintiffs to make a case, if they can, that gerrymandering had an effect on them in their districts. And so we'll see if it comes back up or not.
So we'll spend a few minutes, closing minutes here, kind of previewing the upcoming term. There are no kind of landmark cases that the court has already granted review on, and the court came back from its long summer recess last week and issued its first round of cert grants, since last June. And their number was actually smaller than it typically is. They granted cert in 5 cases. Often it's more than double that, and you could see the impact of having one less justice on the court impact that. The same 4 votes are needed, whether you have 8 justices in conference or 9 to grant cert, and so that might help explain the lower number. One of the cases that came out of last week's order list is this one, Tennessee Wine and Spirits Retailers Association v. Byrd, and it's a 21st Amendment case, which is, and this is the 21st Amendment that grants states virtually complete control over the intrastate distribution and sale of liquor. Tennessee here and many other states, in fact, have exercised that authority to create kind of a 3-tier distribution system that separately regulates producers of liquor, wholesalers, and retailers. And many states, 21, I believe, have also imposed durational residency requirements. So in order to be a retailer in Tennessee, for example, there's a 2-year residency requirement that you first need to satisfy. And there's been a question of, the 21st Amendment being in tension with the Dormant Commerce Clause. And the Sixth Circuit in this case, joining the Fifth Circuit, held that durational residency requirements do violate the Dormant Commerce Clause. That conflicts with the Eighth Circuit, which has held that they are a valid exercise of states' 21st Amendment authority. So again, this case will be heard this term, and it affects 21 different states with similar laws. There are 3 arbitration decisions that are on the court's docket, New Prime, as well as these cases, Henry Sheen, Inc. v. Archer and White Sales, and Lamps Plus v. Varela. All 3 are going to be heard this October. One of them will be heard in 2 days, the New Prime case. And talking about the Epic Systems case earlier that Steve was discussing, the court has issued a number of decisions recently that are very pro-arbitration. And often those have been 5-4 decisions with the conservative majority prevailing. All 3 of these decisions come to the Supreme Court from Court of Appeals decisions that were anti-arbitration, I guess. And so the impact of Justice Kennedy's seat not being filled is going to be very real in these cases, because you need to have sat on the court for oral argument if you're going to issue the decision. And so what one might have expected with a full 9-member court to be a series of 3, 5, 4 reversals may in fact end up being 3, 4, 4 opinions affirming the lower court decision by virtue of an equally divided court.
So we're just about out of time, so I'm just going to skip through some of the cases pretty briefly that are both on the docket and maybe petitions to watch. Apple Inc. versus Pepper is an antitrust case. It involves the indirect purchaser rule under the Illinois BRIC doctrine. And the question in that case is whether or not you can sue the distributor of services rather than the seller of services for monopolization under the Sherman Act. I think maybe we'll just skip over to so an interesting double jeopardy clause coming up in which there's what's called the sovereign exception to the double jeopardy clause, which the question is whether the federal government and the state government can convict somebody of this for a crime of the same act, the same wrongful misconduct, and this will be tested for the first time in a long time. I think on the petitions to watch, one particularly interesting one is Zappos versus Stevens. So there's a huge circuit split right now about whether in a data breach case, a security breach case, you actually have to have standing, you have to show concrete injury. About half the circuits have said, yes, you have to actually show concrete injury, you've lost money, you've been targeted by hackers, something like that. And half the circuits say you don't need concrete injury, that the existence of the breach itself is enough to get you into court and to bring a cause of action. So that'll be decided, and it's not on the docket yet, but it's I think it's quite likely that the court will take this case. Yep. Thanks everybody for coming. If you're on the webinar, thank you for joining us. Thanks.